I'm going to start recording this session as well. So just a reminder to those who were at our previous session, Michael Schwartz and Jeff Scorgie are here to talk about contract documents and documents that you sometimes don't think about, additional pieces of information you have to be aware of. I know in our last presentation, the big takeaway, at least I heard, was make sure you have everything in writing. Don't take a handshake and a spit in a handshake anymore. Just a reminder that both of these gentlemen have been contract lawyers or construction lawyers for numerous years. They have dealt with contract negotiation and they have routinely helped manage construction management projects. Without further ado, I will hand the floor over to Michael and Jeff. Thank you, gentlemen, again for joining us.
Thank you. Jeff, did you freeze? Or
Nope.
Or are you just deep in thought?
Hopefully I just appeared deep in thought. Can you hear me?
We can hear you just fine. So we'll go with just deep in thought.
Okay.
So welcome back, everybody. And Jeff, if you can just move ahead a slide, we'll take a very quick review of what we talked about last Tuesday. We talked about the key documents: short form contracts, supply agreements, purchase orders. We talked about quotes, incorporating those documents, whether an LOI can be a direction and become the contract, or is it just an agreement to agree? And an agreement to agree, of course, is not enforceable. That's not a contract. You can't promise to make a promise. And we talked and finalized things with some change orders, contract amendments, and non-disclosure agreements. Where we left off was about how to get paid, and then finalizing everything with learning how to manage the documents that are coming in. So if we take 10 seconds for station identification, that will give anybody an opportunity to maybe raise their hand in case there was a question about that, or probably most helpful is if we just save it all until the end. So I'll count down from there. 4, 3, 2, 1. Then let's get off to the races on how to get paid. So this will sound like a repeat from last week, and there's good reason for that. Are your contract documents in order? And if time permits, I'm going to give you an explanation when we get down there near the bottom to adjudication on how critical that can change fortunes in your favor. Make sure your contract documents are in order. Make sure that your communications and correspondence are in order. And if they form part of the contract, say so expressly. And worst case scenario, do not undermine yourself by agreeing to something that you've already taken the time, the pain, the blood, the sweat, the tears into incorporating into your contract, only to find out that there's an administrative PO that completely undermines all of that. And Jeff talked about that last week. Is that purchase order something that's systematic? Is it just an accounting exercise, or does that form part of the contract? Because if it forms part of the contract, beware of those words that say all prior negotiations, contracts, discussions are not included in this contract unless expressly said so. And so if you've gone to the lengths of drafting up your PO or your quotation, and you've gone to the lengths of putting in all those key phrases, all those key points that you need to make, especially exclusions, right? Exclusions then somehow become inclusions once you sign everything off. And then, believe it or not, are your invoices in order? And that's actually critical when it comes down to this final bullet that we'll be talking about, the remedies you have to getting paid if all else fails. Jeff, let's chat about invoices.
Yeah, sure. So we wanted to just take a second to talk about the proper invoice. That's a term you may have heard of before, and it's a concept coming from the Ontario Construction Act, but it's coming in force. There's similar legislation that's been introduced in other provinces. like Alberta and Saskatchewan currently, and it's coming in various other provinces as well across the country. But this is with respect to prompt payment. And so we wanted to take just a quick second to talk about what a proper invoice is. And so in the world of prompt payment, under the prompt payment legislation, which again, using Ontario as an example, that's in the Construction Act, it is an invoice between a contractor and an owner. So a contractor is not just a general contractor, but it's anybody who has a direct contract with the project owner. So say, for example, you're working for a developer who's using the CCDC 5A type contracting model where it's a construction management model where they're hiring all the trade contractors directly. In that case, all those trades are actually contractors because they have a direct contract with the owner. But even if you don't have a direct contract with the owner, even if you're a subcontractor or a supplier or a subcontractor, it's still really important to understand how proper invoices work because it impacts your entitlement to get paid. And ultimately, the proper invoice is, as we say here on the slides, the fundamental link in the prompt payment chain. And everything really flows from this under prompt payment. All the owner's obligation to pay the contractor within 28 calendar days, that is triggered by the delivery of a proper invoice. And then the contractor's obligation to pay its subs obligations to pay their subs under the prompt payment rules, it's all basically premised on the delivery of a proper invoice from the contractor to an owner. So if that doesn't happen, the entire chain kind of falls apart. So here, again, just using the Ontario Construction Act as an example, here's that statute's definition of what a proper invoice means. So again, if you're ever in the role of a contractor, again, you have a direct contract with a project owner, you want to make sure you've gotten your invoices reviewed and updated to make sure they capture all of these requirements. So you can see here, the invoice has to include the contractor's name and address. It's pretty basic. The date of the proper invoice and the period during which services were supplied, information identifying the authority under which the work was performed, a description of the services or materials, the amount payable, and the payment terms, the name, title, telephone number, and mailing address of the person that payment is to be sent to, and any other information that is prescribed. And currently in Ontario, there is no other information that's prescribed, so it's just these 6 bullet points that you really want to make sure your invoices include. But I just wanted to quickly touch on, you see here we've highlighted a few of the items in this list because both Mike and I have reviewed a lot of our clients' invoices since these rules came into effect. And on first blush, you'd review this list and think, oh, yeah, our standard invoice templates that get spat out from our accounting software include all this information. But if you actually look into the details, to this day, I don't think I've found a single invoice that a client has sent me to review and update that actually had all this information, because some of it is actually a bit bizarre. If you look at number 2, for example, a lot of invoices don't actually describe the period during which services or materials were supplied. It doesn't say this invoice is for work performed May 1st to May 31st. Sometimes it just says, May bill or something like that, or the May invoice. So that's one to look out for. Number 3
or if I can just interrupt quickly.
Yep.
It will say this is our May invoice. And arguably, okay, that's the time period in the contract from May 1st to the 25th because that's your billing period. But you forget those last 5 or 6 days, so that raises a red flag. The other trip up that I see, Jeff, when I'm off adjudicating is, oh my God, what are we going to deal with here? Because you just got an invoice in from 2 months ago, so you're carrying that one now. Right? Maybe you've gotten a supplier who's delivered an invoice late. And so you say it's from May 1st to May 25th, or you've just said this is the May invoice, but you're actually including something else. Arguably, you've got to tweak that or reference that this is the time period. Plus there's this other item there too. So you're right. That's a wonky one, and one that there's hurdles to get over before you're actually even allowed to adjudicate. And that might be one of those first hurdles to clear.
Yeah, that's right. And another one actually that just occurs to me is if you're invoicing on a milestone basis, then saying the period during which you supplied services is something you probably wouldn't even think of including in your invoice, because it's not really relevant, because you're invoicing, once a milestone's been completed. So, and you just want to make sure it's now added in your new. Number 3 is another bizarre one. Information identifier authority, whether in contract or otherwise, under which the services or materials were supplied. I've got a lot of questions about this. I'm sure, Mike, you have too. The standard interpretation of what the heck does this mean is basically the contract, right? Under what authority were you given that you're performing this work? 9 times out of 10, hopefully, especially if you listened to our last presentation, you have a signed contract. That's the authority, right, under which you're doing your work. So, normally I recommend clients including a field in their invoicing template that says something like, where you put in maybe it's a contract number with the date, or perhaps the contract has a title, but something to identify the contract that you're working under. And then number 6 is perhaps the one I find that I don't think I've seen to date anybody's invoice actually include this when they've sent their invoices to me to take a look at. And this is the name, title, telephone number, and mailing address of the person to whom payment is to be sent. Now, this is very bizarre because most of the time, your invoices aren't addressed to a particular individual, right? It's addressed to a company, perhaps to somebody's attention, maybe. But a lot of the time, you're just, your invoices are addressed to the company name and address. But they actually want, what the statute is saying here is you actually need to include all this very detailed information of a actual individual, like Bob in accounting or something. So it's bizarre, it's strange, but it's something you want to include, because again, if you're a contractor, you want to make sure your invoice includes all this information, and you're not, as Mike said, trying to jump over this hurdle in an adjudication when the other side is saying, your invoice isn't technically a proper invoice because it didn't include, the information in item 6.
It seems so unfair, but again, these are the other guys. These are the things that you don't think are part of your contract or isn't a contract. And a proper invoice, whether it's referenced in your contract or not, remember, you cannot contract out of construction rights. And so these invoices are part of the contract.
That's right. And kind of the other item that you want to take note of for your proper invoices is that your invoice, you can see here, we've highlighted it on the screen, your invoice, in order to be a proper invoice under the prompt payment rules, has to meet any other requirements that the contract specifies. So you have these 6, what I kind of refer to as the fundamental pieces of information every invoice template has to have. But then, unfortunately, your invoices, you have to make sure they also include anything else that the specific contract for that project is specifying. So we've listed here a few examples of some, common additional things we often see, or sometimes we've put into contracts between owners and contractors. Things like a WSIB clearance certificate, statutory declaration, maybe it's the CCDC 9A statutory declaration form, which is commonly asked for with monthly invoices. Maybe the contract requires you deliver an updated project progress schedule or a look-ahead schedule. Sometimes the contract may specify, you have to identify any amounts being claimed under change orders or change directives separately, break them out from the full amount you're invoicing for. Maybe include your HST registration number. And then sometimes if you're doing work on a time and material basis or a cost plus basis, The invoicing terms in the contract are often quite a bit more robust. So often there's, requirements for a lot more backup documentation, such as, your subcontractor, supplier invoices, maybe timesheets, things like that, right? Other invoices and, receipts supporting any reimbursable expenses. So you want to just make sure, if you can build it into kind of your project processes, that there's some, whether it's, through a checklist or some sort of internal process where you're making sure that on every project, somebody on your team is going through and reviewing and, putting a note to file saying, okay, we have to make sure all our invoices include all these additional items that the contract specifies. It's really important. Then in terms of delivering proper invoices, just a quick note on this, because again, we've seen a few hiccups on this, and certainly Mike has, and when he's been advising clients in adjudications. It's important to remember that a few points about delivering proper invoices. So again, under the Ontario Construction Act and the other provinces, Alberta and Saskatchewan, they have similar language. Proper invoices, the kind of the baseline is that invoices are delivered on a monthly basis, but your contract can provide otherwise, right? So the default is monthly, but if your contract says biweekly or maybe on a milestone basis, then you'll have to deliver your invoices in accordance with those requirements. It's also important to remember that the invoice has to go to the owner. So a lot of folks, previously, kind of before the prompt payment rules were introduced in, before 2019, common practice was to send invoices directly to the payment certifier or to the owner's contract administrator. But in order to be a proper invoice, it does actually have to go to the owner. It's also important to note that there's no requirement in the statute for an owner to tell the contractor that its invoice is not a proper invoice. So let's say, for example, you are missing the name and address of your company on your invoice. The owner actually doesn't have to tell you that even if they know about it. Technically speaking, now most of the times in my experience, owners will tell you. They'll say, or their payment certifier will tell you you're missing X, Y, and Z. But they may not, and there's no actual obligation on them to do that. So that's why it's all the more important that you just make sure your invoices have all those proper invoice requirements, so that you're not waiting until day 27, and then all of a sudden you find out, that the owner says, oh yeah, you missed your company name and address. You don't want to be in that position. And then finally, there is one kind of important exclusion to keep in mind, and that is that the statute says that a contract can't make the giving of a proper invoice conditional on prior certification of a payment certifier or the owner's prior approval. What does that mean? Well, the legislators, the folks drafting these amendments to the statute, wanted to get away from this practice that was kind of ingrained in the industry for years of requiring contractors to deliver with their invoice, or essentially saying you can't invoice unless you provide a signed off payment certification from the payment certifier. So what it ultimately meant is that contractors and payment certifiers were working back and forth. Payment certifier was marking up their invoices saying, nope, resubmit it, nope, resubmit it. And it was basically the payment process was such that the contractor couldn't actually submit its invoice until the payment certifier had fully signed off on the invoice. The Construction Act has now essentially outlawed that whole process. So what that's led to, in effect now, is a lot of owners and their consultants implementing kind of a draft invoice review procedure. But so that might be in a contract, and you might see that. It's certainly becoming more common. But it's just important to keep in mind that an owner can't actually make you agree to a provision that says you won't submit your invoice until the payment certifier or the owner has approved your draft invoice. So that's important to keep in mind. Now, I'm just going to quickly, before I turn it back to Mike, just quickly run through the prompt payment rules, just because, I'm sure some of you may have seen perhaps a presentation on how these work, but it's important to keep in mind just when you're drafting those invoices, drafting your purchase orders and subcontracts and the payment terms, it's important to keep these prompt payment rules in mind because they are kind of at that this level hovering above all your contracts. And as Mike said, you can't contract out of them. You can't agree to for them not to apply on your project. So it is very important to keep these in mind. So if we look at the top here, this is kind of the goal. So this is the scenario under a project where there are no payment issues. So if everything goes according to plan, essentially the contractor would submit its proper invoice on effectively day 0. Then 28 calendar days after that, the owner would have to pay the contractor in full the amount of its invoice. 7 days after the contractor receives money from the owner, it has to pay its subcontractors. And 7 days after the subcontractors have received money from the contractor, they have to flow money down to their subcontractors and so on. Everybody paying within 7 days down the full construction pyramid. So now what happens if the owner wishes to dispute the contractor's invoice? Well, if that's the case, then they have to deliver a notice of non-payment 14 days after the owner has received the contractor's invoice. And that's a prescribed form. You can just find it online if you just Google the Construction Act forms. So that the owner would have to fill that out, specify the amount that it's not paying the contractor, and then deliver it to the contractor. The contractor then would have 7 days to give its subcontractors a notice of non-payment, assuming it wasn't just going to pay its subcontractors out of its own pocket. And then subcontractors have to pay their subcontractors within 7 days and so on. Again, everything's kind of 7-day increments. Now, what about if the owner doesn't deliver a notice of non-payment, but they just day 28 comes and goes and you're the contractor and you don't get paid? What happens then? Well, it's kind of the same as the previous row, but everything's just delayed a bit. So day 28 comes, the contractor hasn't gotten paid. It now has to notify its subcontractors, providing a notice of non-payment to them. I haven't got paid by the owner. Take note and specifying the amount that the contractor is not paying them. And then in that case, the contractor essentially is compelled to make a decision. Either it has to pay its subcontractors, as I said previously, out of its own pocket. Assuming it's not going to do that, then it has to commence an adjudication against the owner, effectively to chase the funds. So what the prompt payment regime is doing is forcing contractors not just to sit back on their hands if they haven't been paid by the owner, but to actually pursue the owner through adjudication to try and get the money. Now, what about the scenario where the owner doesn't have an issue with the contractor's invoice and so pays the contractor in full, but the contractor has an issue with its subcontractors? Well, in that case, the owner would pay the contractor in 28 days. And then again, within 7 days, the contractor would have to give a notice of non-payment to its, the problematic subcontractor that it has an issue with. And then again, the subcontractor has 7 days after that to notify its subs or pay them out of its own pocket. So that's a brief kind of 10,000-foot overview of the prompt payment regime. Mike, before I turn it back over to you, anything I've missed or anything you'd add? I know we could go on about that for a couple hours, but anything I've missed from a high-level view?
From a high-level view, and if there are a few items we want to highlight, we're going to highlight them when we give a few examples a little bit later on.
Sounds good. Okay, turning back over to you.
All right, so we've seen this slide. We've grayed out these 3 items and concluded that with invoices being in order. Failing that, you've put all of your contract documents together. You have put your invoices together, your communication, your correspondence, all of that is together. Failing all of that, how do you still get paid? Number 1 is the contract dispute resolution process that might be in your contract. So last week we talked about, is the prime contract incorporated into your contract? Or put a different way, if you are the one fending this off, have you given access to, have you delivered a copy of that prime contract? And why that's important, of the many reasons of why it's important, is that the standardized industry contracts that we have, such as the CCDC or the CCA, they have a dispute resolution process, and that dispute resolution has to be followed. And if it's incorporated, then it goes a little something like this. I wish I played guitar so I could hit a few notes now. and that's this. First and foremost, have you gone to the consultant and have they made a determination? If they've made a determination, then has either side disputed that determination, usually within 10 or 15 days, unless it's amended by a supplementary condition. If that's the case, the next step that has to take place is that there has to be a meeting between senior management members. Now, not so senior that it has to go all the way to the president of a worldwide corporation, but senior enough to be a decision maker. And they have to have a meeting and see if they can break the logjam and resolve or settle the dispute. If after that the dispute is not going anywhere, or it's still a live dispute, the next step is that either party can refer the matter to a mediator. In a mediation, if you haven't had the luxury of participating in one, is that the two sides are there and there is a neutral mediator. And that mediator's job is not to settle the dispute and make a determination. It's to try and facilitate a settlement that the parties can reach. And so that's often done in person, although virtual, since the pandemic started, seems to still be a way that people do it. This is especially helpful if you've got parties in remote areas or there's difficulty or challenges with traffic or geographical distance, that you can do it virtually as well. Normally what happens is everybody meets in a big session first. An effective mediation tool that I use when I do end the mediator, and what I see when somebody else is the mediator and I'm the lawyer there on one side, is that instead of having opening statements from either side, it just doesn't work. It just starts getting people with their backs up, becoming very defensive. So normally what an effective mediator does is says, I got the material. This is what I understand from the contractor. This is what I understand from the subcontractor. Do I have that correct from a very high level? And normally people will say, yep, that's good at a very high level. Then the mediator will go through what the process is going to look like if they haven't done that right from the outset. And then you break off into separate rooms. Physically or virtually, you break off into separate rooms, and the mediator goes back and forth. And not just a shuttle, a piece of paper that says, I hear 50,000. What do you got? I say I want to be paid $10,000. Okay, so we're 60,000. It's not that. They go through, they make you realize where you might make concessions. They see if there's an ability, a willingness to make some concessions. And at the end of the day, if there's an agreement, the two sides can come together again in the same room, virtual or physical, or they stay in their own separate rooms while you actually paper the deal. If that doesn't happen, then there may be an arbitration process. And if it's mandatory, it means all of these other things might not be effective, except for adjudication and except for an L&M bond. But then the parties have to go off to arbitrate. Well, that changes things for you if you find that you are arguing over an $8,000 change order, whether you're arbitrating or not, whether that prime contract has been incorporated. And if it has been incorporated, if there is a way to not have to deal with an expensive process. Arbitration is fantastic. It gets things done. It's not fantastic if the costs of getting paid are going to outweigh what you ultimately will get paid. So the contract dispute resolution process has to be followed. You'll look at your contract for that. You could have a regular lawsuit, just a breach of contract. This was the agreement. Hopefully it wasn't, as Laurie said, a handshake and some spit. If that's what it is, we'll deal with it. That's what we got. That's what we'll deal with it. You play the cards you're dealt. Hopefully you've got your PO. Hopefully, you've got your invoices in order. Hopefully, you've got your quotation in order. Or if you're using a standardized document, that you're bringing all those documents in. And so the regular lawsuit is something you have to start within 2 years from the date that you knew you had a right to sue, or you should have known you had a right to sue. That triggering date for 2 years is usually when you've invoiced, or at least the work you're invoicing for has been completed. And so you have a regular lawsuit, you go through the courts, whether that's the small claims court, whether that's a full out lengthy Cadillac version of a trial, or somewhere in between, has yet to be determined. And that's also determined on what you're suing over. If it's up to $35,000, it's small claims court. Moves pretty quickly. Don't really need a lawyer for that. If it's between $35,000 and $250,000, then you are in that middle Goldilocks ground of doing a little bit of it efficiently, changing some of the rules. And if it's over $250,000, you're in the Cadillac version of the court process. You could also just have a lien claim, which follows a lot of the regular lawsuit, but things are done a little bit differently. And the idea is that lien claims move faster than regular lawsuits. The other nice thing with a lien claim is that when you register your claim for lien or deliver it, if you're working for a public owner, you start that process. There's tight timings. You have to have it usually within 60 days from the last day that you were providing services or materials. You start your lawsuit 90 days from the last date you could have done a claim for lien, and you're in the process. If it's here in Toronto, there's actually a specialized court, a construction lien court that you go through, and things move rather quickly. The nice thing about a lien claim from a regular lawsuit is that with a lien claim, in theory, if the person who owes you money is proven to owe you money and they do not pay the money, then in theory, the sheriff comes out, sells the property, and funds get dispersed. And this isn't a lien presentation. We can certainly do one of those in the future if the membership would like. But it moves quickly, and if there is money posted in court rather than the sheriff coming out to sell the property, then the accountant of the court actually pays you out. There's breach of trust claims. You can have a lien claim and a breach of trust claim at the same time. They just can't be in the same lawsuit for whatever reason. And that breach of trust is pretty big, because instead of just suing the contractor you bargained with, 1493612 Ontario Limited, you can also sue the officers, directors, or any controlling mind of the corporation personally. So their personal assets are up for grabs if you prove that you're owed money and you prove that the person who owes you money had the money and spent it elsewhere. Sometimes you find that some contractors get money on one project to pay the last project, and that's a breach of trust and can open it up to a personal attack. The labor and material payment bond, or known as the L&M bond, that's part of the prime contract between the owner and the contractor. Normally, you have a performance bond and a L&M bond, and that L&M bond is to avoid liens and to ensure that people get paid. And so if there is an L&M bond and you're somebody who's owed money and hasn't been paid, you can start yet another action and sue the bonding company and say, this is what I've done. Here's the contract. The contract is my quotation. Flip it over. Here's all the terms, or the PO. Those are the two big ones that we keep going back to as contracts that you don't think of as contracts. Here's the agreement we made. I did the work and I haven't been paid. And if you can prove it to the bonding company pays you out. And what the bonding company does, because the house never loses, the bonding company goes back to the contractor and gets paid out because there's guarantees there. There's personal guarantees that are likely there. So that's another great one. If all of that fails, or on top of bringing a lien claim, a trust claim, and an L&M bond claim, if you really want to go all missiles pointing, you can adjudicate. And adjudication doesn't even have to be in the contract. Adjudication is just there for you to exercise. And it actually is, in theory, a simpler method, because adjudication is something that's under the Construction Act. It is along with prompt payment that says if you have a dispute, a discrete dispute, maybe it's just over a change order, you can move to adjudication. And in that, instead of proving the entirety of a project, you say, here's the change order. Here's the drawings that we were given. You can see that part of the drawings calls for this, this, and this. owner made a change, or the owner wasn't asking for this in the drawings, so our price didn't include this based on the drawings. And so this is an extra to the contract. And so you're submitting your contemplated change notice or a quote for that extra work. You're showing the drawings. You go off to the adjudication. And in theory, and we'll see a diagram, within 35 days, you'll have a dispute. And if you lose that dispute, you can sue later. It's interim binding. So as long as the project's ongoing, you have a referee, the adjudicator, make a call, yay or nay, and you either get paid or you can keep your powder dry until later and fight about it later. Same goes for the owner. If the owner has to pay, they have to pay within 10 days, or they can appeal it, but only if they pay. And if they haven't paid, they have no right of appeal. And at the end of it, they can dispute it. Adjudication is based on a system that the United Kingdom has had since the early 80s, and it has worked, and it's worked well. We've had it now since October 1st, 2019, if you fit into adjudication, and it works well. And I'll give you a couple stories in a second, but if we can go to the next slide, Jeff, let's just look at adjudication really quickly. So the process first is one party to a dispute gives a notice of adjudication, and you'll see we have it highlighted there. And so you go to the ODAC website, the Ontario Dispute, I can't even remember what the acronym is, Jeff. You go to ODAC's website, you file online a notice of adjudication. And in that first file that you are filing within that ODAC system, in the ODAC system, think of it like Tarion. Tarion governs the Ontario New Home Warranties Plan Act. ODAC is the institution that carries out all of the adjudication process. And so you put in there, this is who I am, here's who I have a dispute with. The dispute is, I think this is a valid contemplated change notice. The owner has said it's not, it's already included in the scope. So I would like an adjudication, and you go in and you can select which adjudicator you want. You might want an adjudicator who is a retired judge, or a current lawyer, or a retired lawyer, I suppose, although I don't think there's any retired lawyers in there. Or you want an architect, or you want somebody of a different discipline. Maybe they are an engineer. Maybe they are a contract management person, and that's their area of expertise. You can pick the adjudicator you think is most appropriate for your dispute. Now you see two arrows going in two different directions. The adjudicator may decline, and they may decline because they'll say, you might not know this, but I used to work for Scorgie Construction. And so, although I would not be biased, it might be seen that I'm being biased, especially if I award in favor of Scorgie Construction. Or they may say, I've got too many adjudications. I can't fit these timelines. I'm going to decline. And if that happens, the ODAC institution comes and appoints somebody, and they're supposed to do that within 4 days. Once they appoint somebody, that adjudicator has to consent within 7 days. The alternative arrow is that you choose an adjudicator and that adjudicator consents. You're underway within 4 days. From there, the next step, Jeff, is that the party who gave notice at first step then has to give the adjudicator all their documents. And those documents, as I alluded to, might be the drawings. It might be some correspondence. It might be that they are just giving a copy of the purchase order and saying, I've done the work and I didn't get paid within the 28 days and there was no notice of non-payment. Those are the documents you give to the adjudicator. From there, the adjudicator has to make their determination, and they're supposed to do it within 30 days. I have a yellow asterisk there because the parties can consent to it being a little bit longer. There's also a step missing in all of that, and that the party giving notice gives the adjudicator all their documents. What's missing from the statute is, well, what about the responding party? Do they not have a say in all of this? And so normally what you have is an adjudicator meeting with the parties, and you build out a timetable that fits that 30 days, unless it has to be longer and you consent. And so you will have things like, okay, I have the documents that party A has given me. Party B, you will deliver documents within 5 or 10 days. The party who started this process might want to respond to that. So within 5 days, they have that. Sometimes the adjudicator will say, I'm going to need an expert to explain to me what these drawings actually mean, so you're jointly going to retain them. Or I might need some witness statements, or they might say, I want to take a view of the premises, or they might say, I need to have some live evidence. At the end of the day, though, the adjudicator makes that determination, usually within 30 days. And so what happens from there is payments made. The adjudicator says that you owe payment, then payment has to be made within 10 days, and then this cascading effect of 7 days. Payment made to subs, subs pay to the sub-subs, and so on and so on. If they don't pay, 1, you can get interest on the amount. 2, you can now take this decision and lien. 3, you can go off to court and say, I want to turn this into a judgment so I can go to their bank and seize any assets they have to pay this. Or they can stop work. Or you can stop work. And not only that, sometimes you call a lawyer and say, well, what do? Do I stop work? Like, this is costing me money to keep going here, and they're not approving this. Well, the legislation says you can actually stop work with no penalty. You can actually get paid to resume work. You can get paid to demobilize. So that's pretty potent. The last thing that can happen from that is an application to set it aside. And usually the person who owes money wants to go off and appeal. It's really, really hard to get an appeal, because there is a level of deference that the court, the divisional court is the name of that appeal court, will say, well, it's interim, so you can sue later, but for right now, you have to forever hold your peace. The only way you're really going to be able to set it aside is if the adjudicator got something critically wrong, because the decisions from the divisional court so far says this defeats the purpose if you keep going off to appeal. Let me tell you a couple quick stories about the adjudication process and applying it to some real world facts. This first one, I think, is just underscores critically what you're going to do in terms of making sure all your contract documents are in order. So this case actually did involve a CCDC, but it was an interesting case in this sense. And that is, there was a public owner, it was a school board, was calling for a tender for the demolition of an existing school and the building of a new school. And it was a very tight timeline. Most of that work had to be done over the summer months. So you started the last day of classes with the demolition, and at the same time, the school wasn't going at the exact same location. So simultaneously, you were erecting a new school on the property grounds. And so all of the major work was supposed to be done in July and August so that the school was open again in September for classes to resume. Lo and behold, the owner says, okay, we're actually going to have to delay this because there's a funding issue that's going to impact how we afford this project. So the school board wrote to all of the various bidders and said, will you hold your price? And our client said, yes, we'll hold our price. But, and this is all done in an email, but you have to understand that this is a pretty volatile market and things may change. You have to work with us. That might mean that you have to pay more for certain items. That might mean that the prices we do have and the availability of trades that we do have as part of our bid might shift. We may have to postpone works, or you may need alternative sources, or you might just have to pay more. And so that was how it was left in September. So classes have already resumed. The project has been started in September. Our client gets a notice that they have been awarded the contract. A copy of the CCDC gets sent to them, and they take a look at it at the end of September and say, well, hold on. You've excluded our email that you said, yeah, we agree. If you're going to hold your price, we'll work with you to make sure that we can get this project done. I need this email as part of the contract documents. There was some back and forth there. Finally, appended to the CCDC was this email exchange, yes, but, and the agreement from the other side. As luck would have it, as fate would have it, the process actually changed. The roof cost more. A contemplated change notice went in. The structural steel cost more. A contemplated change notice went in. The public owner, the school board, said, you're stuck with your price. It's a fixed price contract. Go deal with your sub. We have our price. And so the adjudication process came all down to that email and incorporating that email as part of the contract. So as another life lesson of the other guys, it was called the escalation clause. The escalation clause was an email. The email formed part of the contract. And what shocks me to this day, shocks Jeff, I think, too. Not only did the contractor win, but I think they overwon, because not only did they get the contemplated change notice turned into a valid change order for the roof and for the structural steel, they actually were awarded payment. So before they've even done the work, they got the payment. And I remember the lawyer for the school board calling me and saying, well, this is wrong. And I say, what are you going to do? What are you going to do? Payment has to be made. I'll tell you what, make the payment. It'll stand there if there's adjustments to be made after the fact. The lesson of the story isn't that victory. The lesson of the story for our purposes, an email became part of the contract. An email became one of the other guys that you rarely think of as being part of the contract. So that's that on the adjudication process and my real world example. I have one more if we can go to the next slide here. And that's cases are won or lost on your paperwork. You've heard this before. It's important. That's why you're hearing it again. Are your contract documents in order? Are your communications and correspondence in order? Are your invoices in order? Different case from several years ago, but it was all based off of a purchase order. So the quote came in for electrical. I believe it might have even been another school. But whatever the case may be, let's go with the school, because I do think it was a school. I think it was a private school. The quote was given for the electrical work. There was a number of exclusions that were put in there. Remember what I told you about exclusions, and don't undermine things. Our client sent back its standard purchase order and says, we're prepared to move forward. Here is our standard terms and conditions. If you flip over our PO on the back, you'll find everything. There was reference to the prime contract, number one. Number two, and maybe I'll tell you what the dispute was about first, so you'll hear what was important about the purchase order and how it won the day for this client, is the purchase order had a bunch of conditions. The dispute was over temporary electrical work. Who pays for that? Because on the quote, it said, does not include temporary electric, or maybe it had said, contractor, you're supplying all the temporary electrical. And so that was part of the dispute. Who pays for the temporary electrical? The other part of the dispute was that the electrical subcontractor tried to make an extra and said, well, all that electrical work for the lamp standards we did out in the parking lot, that's extra to the contract. Lo and behold, if you flip over that one piece of paper that's a purchase order, all the details about the scope of work on the one side, flip it over, and in a small font, but it all fit on one page. Remember, that's what we talked about, even just the appearance last week. All fitting on one page were two key things, and I'm paraphrasing. But number one said, it includes every part of your scope of work unless these terms and conditions on this PO provide otherwise. So the claim for extra work, it actually said that you have to read all the different divisions. And so it wasn't limited just to the electrical division, but you also had to read, in addition to Division 1600, you had to read Division 15. And Division 15 had the lamp standards there. So score one huge point for the contractor on that. The electrical lamp standard work, part of the contract, not a valid extra. On the temporary electrical, there's a poor electrical subcontractor who said, one of my exclusions is you're providing the temporary electrical. Of course, on the PO, on the back of the page, pretty simple, all of the work, all the means, all the methods, all the techniques, unless expressly excluded here. And so at the end of the day, you've got a contractor whose other guy, the purchase order, beat out the other guy, the quote. So, and then in terms of the claims, make sure you comply with the contract's claim requirements, the notice content, the notice of timing. In this last example I gave you, there were some emails back and forth, but making sure your paperwork is in order, the contractor thankfully kept writing back and saying, no, look at the terms and conditions of the back page here. They would actually screenshot it and include that in their correspondence. They had italicized all the words. At the end of the day, that's what won that claim process. That's what, I guess, didn't make it for a payment, but at least pushed back on the payment. So we had allotted 15 minutes. Laurie, I'm so sorry. We've given 10 minutes for questions. But as I said last week, we will stick around if we have to a little bit longer. We understand that people may have to sign off, but don't forget the other guys.
No, thank you very much, gentlemen. That was a lot of information, and I'm sure people appreciated you running a little bit over so that you could complete all the information you need to share. At this time, if you do have a question, please just unmute yourself, state your name, and go ahead and ask.
Hello, how you doing? Jerry Cole here, Cole Tech Quality Woodworking.
Hey, Jerry.
The ODAC thing you were talking about, adjudication, is there a time limit on that?
The time limit is so long as the project is still ongoing. And even there, you might get a little bit because I've read some of the ODAC decisions. So let me take one step back. With a court case, I can look at what other judges have said because it's published somewhere and we continue on. With ODAC, they're not public records, so I know this because I've been involved in a number of adjudications, so have my colleagues, and we share those decisions amongst ourselves. So there's no, you can take this to the bank, Jerry, but I have seen where the work is complete, but there is an outstanding claim amount owing on a particular invoice. And adjudicators have said, well, the project isn't complete. The project's only complete when there's no more work left to be done and everything has been paid. And so if you still have an outstanding payment and it's relatively within time, I think you're going to be fine still getting it in. I'm hesitant and cautious because I'm a lawyer and I'm always paranoid, and I think paranoia is a healthy thing in small doses. But also, I just had a case that I successfully defended against where the owner came back to say, I've paid you, I want a rebate, and it had been 10 months since there had been one. And that was enough for me to successfully stop the owner from trying to claw back monies from the contractor. So is there a time limit? Never trust a lawyer to answer a question with just a few words. Is there a time limit? Strictly speaking, it is so long as the project's ongoing. If the project has come to an end, you're looking at a different way to collect, possibly the L&M bond, breach of trust, regular action, or a lien if you're still within time.
Okay, thanks. One more question is about stat decks. When they ask you to sign a stat deck prior to getting paid, you are actually declaring that you've already paid your sub-trades, so you have to sign a stat deck stating that I have paid them, but you can't pay them until you receive the money.
I hate
Jerry,
stat decks. Go ahead.
Yeah, no, I can address that. So the latest version of the CC, if you're using a CCDC 9A or 9B statutory declaration, as opposed to say the client custom statutory declaration form, this standard CCDC language actually only refers to, you're only confirming you've paid your subs with respect to the last progress draw received. So you could technically argue that, well, I'm not offside the stat deck because the last progress draw I received was is not the most current one, but I usually suggest just raising it with the client if you can and just say, guys, this doesn't make sense. This isn't this timing doesn't make sense. But hopefully you're using it. That's another reason just to insist on using the CCDC language because it is much better in that way, and it's just tied to the last money you've received. So you're not making any kind of prospective statements, any statement about anything in the future.
I'll go further, and why I don't hate, it's such a strong word, I don't hate stat decks, but stat decks aren't everything they're made up to be. If you're the owner or if you're the contractor giving it, or the contractor giving it to the sub, or the sub giving it to the contractor. What Jeff said is it's not prospective language, it's what has come past. But there's also exceptions. So what comfort are you really getting? And those exceptions say, I've paid all of our people that we've had to pay, except for holdback, number one, except for monies that are properly in dispute, and who is the arbiter of what's a proper amount in dispute, because I'll bet you'll get two different stories. or the third, which is rarely the case anyways, says we've agreed to have a deferral on this. And so the stat deck is nice to have, and it says, yes, it's a criminal offense if you lie on this. But you'd really have to prove that retrospectively they actually haven't paid, because you fit into those exceptions. And on the other hand, if you are feeling tense about signing it, know that if you're using the CCDC version, the 9A or 9B, it actually is, it gives those exceptions in there as well.
Okay, thanks.
Are there any other questions?
All right. If there,
Well, if no one else can
okay,
ask,
good.
I will ask one more. Did you say it's 60 days from your last day on site for a lien?
I said 60 days from the last day you supplied materials or services, but even that's a complicated answer. Because if you're a contractor, and a contractor is somebody who has a direct contract with the owner, then it's 60 days, and even that has a caveat, but it's 60 days from the date that substantial performance has been declared and published, or the date that the contract's been terminated or you've abandoned it, or the last day that you were providing materials or services and it's been complete, right? Because the contract might actually be suspended, but that doesn't mean it's complete, and that doesn't mean it was your last day on site. If you're a subcontractor, it's 60 days from the date that the prime contract has been achieved substantial performance and published, or your subcontract has been certified as complete, or the last day you were supplying materials or services. And why I refuse to use the words last day on site is people will sometimes think I can revive my lien rights if I go and just look at whether or not this item is working, or I just go on site to say I was on site. You actually have to be supplying materials or services. It's 60 days if the project is a project that dates from July 1st, 2018 or onwards. If you happen to be on some legacy project, it's still 45 days. So that's why the answer is complicated, and why we often do a full presentation just on liens to show how that works. But 60 days, Jerry, if you were wondering, why is it not 45? It changed to 60 days, and there's triggering events, and it's the earliest triggering event. So if you have finished your contract, but substantial performance gets published 2 months later, you count your time from the earliest triggering event.
When you say published, like a job I'm talking about, they published in the Daily Commercial News on May 5th, I think. So is that the only place they can publish, or they can publish it somewhere else?
They actually could publish, there's two others I know, Link to Build or the Ontario Construction Reports. But if they've published in the Daily Commercial News, they probably only published in the Daily Commercial News. And so long as you were doing supplying materials and services up to May 5th, then you're going to be fine. If you were last on site on April 5th, for example, your timing might be out because that was the earliest triggering event.
All right, thank you.
All right, well, I'll just say this then, Laurie, before we wrap it up, is you may have a question that you haven't completely formulated in your mind. Jeff, if you go to the next slide, and you guys are going to get a copy of these slides, here's our contact information. If you think of something that comes up, send us an email, give us a call. We'll answer it the best we can. If we can't answer it, we'll think it through and get you an answer. If we can't get the answer, we'll make up an answer, and you'll never know the difference. But we'll come up with some sort of an answer for you. So again, we'll stick around for a couple extra minutes, but I'm sure Laurie is probably looking to wrap this up and let everybody get on with their day. You could have been anywhere. You chose to be here with us, so we thank you for spending an hour with us today.
Yes, thank you both, Jeff and Michael, for joining us today. As always, you're always very informative. It's always extremely interesting to hear what you have to share, and we thank you for your time. You've taken time out of your day, so we all greatly appreciate it. And yes, I will have this up on our YouTube channel, hopefully before the end of today, along with the slide deck in PDF format. So if you would like
Can we get to 2 million likes, Laurie?
Not quite there yet. So if you have any further questions, please stay on the line, or as Michael mentioned, please feel free to send an email. Thanks, everybody.
Thank you.